My name is Melissa Britton. I'm going to be your host for the presentation. I'm on Treaty 6 territory, Amiskwaciwaskihakan, Edmonton, Alberta. I was born in Toronto of French, Irish, and English heritage, and I've been on Treaty 6 territory since 1999 now. I've been honored to work with the Caring Society for 12 years now as the research associate for FN Cares. It's the research and education little unit for the Caring Society. And I'm also currently the policy and research coordinator for the Caring Society. The reason for the presentation today is there's going to be a tribunal hearing September 10th and 12th on the most recent non-compliance order for Jordan's Principle, Canada's non-compliance. So in light of the upcoming hearings, we wanted to provide people with as much information as possible so they know, have a good background of what's going on, and they know what to watch for during the hearings and for the ruling that's going to come out after that. We have 6 topics to cover. So let's get started. I'm going to introduce our speakers first, and then we'll just get right into the presentation. David Taylor is an Ottawa-based lawyer and the managing partner at Conway Litigation. Among his many achievements, David has appeared before the Supreme Court of Canada on 8 occasions. It might be more now. This bio might be maybe not updated so well, and has also appeared before a number of courts and administrative tribunals at the federal level and in Ontario, Quebec, British Columbia, Manitoba, and Nova Scotia. Since 2014, David has served as pro bono counsel for the First Nations Child and Family Caring Society and the Human Rights Tribunal complaint, helping to achieve the tribunal ruling in favor of the kids in 2016. In 2017, David took the lead in the tribunal hearing on Canada's failure to adhere to the 2016 tribunal ruling to implement the full meaning and scope of Jordan's Principle. That hearing led to the tribunal orders clarifying the definitions of Jordan's Principle and laying out the processes Canada is required to follow for tracking and reporting on Jordan's Principle cases. Since then, David and colleagues on behalf of the Caring Society have filed multiple non-compliance motions, the most recent citing Canada's chronic and willful failure to adhere to the tribunal's orders on Jordan's Principle, which they filed in December 2023. The hearings on this matter take place, as I said, on September 10th to 12th. Now, Brittany Mathews is Métis and a member of the Métis Nation of Alberta. Brittany's family more recently comes from St. Paul, Alberta, with kinship relations from St. Francois Xavier in Manitoba. Brittany is the Research and Reconciliation Coordinator for the Caring Society, and she's honored to have worked alongside First Nations, Métis, and Inuit youth to research and write reports on ethical accountability mechanisms and ethical research requirements when organizations and individuals conduct research with Indigenous youth, and just ethics in relation to working with Indigenous youth in general. She works closely with Dr. Blackstock and the Caring Society's legal team, taking an active role to ensure Canada's compliance with the tribunal's orders on Jordan's Principle and Child and Family Services. She has given countless presentations and workshops on Jordan's Principle and ensuring non-discrimination for First Nations children to community leaders, service coordinators, and other interested parties. Brittany's day-to-day work at the Caring Society involves responding to community members who are having issues accessing Jordan's Principle, which gives her unique insights into the challenges First Nations children and caregivers experience because of Canada's non-compliance with the tribunal's order regarding Jordan's Principle. So we're really delighted that she's joining us today. Thanks, Brittany. Thanks, David. Okay, so we're going to get started here on the first topic that we have, which is the history of Jordan's Principle, including previous non-compliance orders. And David's taking this one on. Thank you, David.
Thanks very much, Melissa, and it's nice to be here this afternoon in Ottawa to talk about this very important topic. It's consumed, probably about 96% of my legal career, and that I was a lawyer for only about 6 or 7 months before I got on this case. and now it's been 11 plus years here. So I'm going to start at the start, and for a lot of people on this call, it may be very basic you know information already, but I think it's always really important when we start these big conversations of Jordan's principle to go back to the start and Jordan's story. And so as people, most people on the call on this webinar likely know very well, Jordan was a little boy who was born to a family from Norway House Cree Nation in Manitoba. And he had a number of complex medical concerns that intersected and really meant that he needed to be, when he was born, in a hospital to have his needs met. But by the time he was about 2.5 years old, his doctors had come up with enough of a plan, and his condition had stabilized enough that he could leave the hospital and be in a family home. And there was a plan for him to go to a therapeutic foster placement in Winnipeg, which would have been a nicer environment for him to be in, certainly a nicer environment for family visits, all these things, and close enough to the Children's Hospital in Winnipeg that he could have outpatient care. Pretty good plan. Now, there's a problem with this plan in that those responsible for paying for it, which is the government, because we have public health care in this country, couldn't decide who should do the paying. And so first, it was a dispute between Health Canada on the one hand and INAC, Indian Northern Affairs Canada, as it then was, between whether this was a health case or a child welfare case. Because if it was a health case, that would be in Health Canada's bucket of funding. And if it was a child welfare case, that would be in INAC's bucket of funding. But then the two departments said that actually this is really a provincial problem, because it's a child welfare placement off reserve, because it was a therapeutic foster placement was how it was billed. And so because of that, the province of Manitoba should pay. And the province of Manitoba turned around and said, no, Jordan is an Indian Act status child who would have been resident on reserve if not for all of this stuff. So we're not paying, the feds should pay for it. So, I mean, it's taken me about 3 minutes to explain the dispute, but it took, years for it to work its way out. And the result is it never really did, because Jordan passed away at the age of 5, or close to the age of 5, never having got to leave the hospital clinical setting and live in a family home. And so with, in my view, a lot of courage and a lot of guts, Jordan's family and Jordan's community and other organizations like the Caring Society, the AFN, the Canadian Pediatric Society came together and brought forward this idea of Jordan's principle, which was that First Nations kids shouldn't wait for services that they deserve while others are, fighting over who should pay for those services. So essentially, whatever counter you end up coming to, you get the service, and then the 2 counters or 3 counters in this case, figure it out amongst themselves. So it's a pretty straightforward principle. It's certainly consistent with what we think of in healthcare as, the do no harm principle, and what we think of in child welfare as, intervening in the best interests of kids. And so that was, put about in about 2005, 2006, and by 2007, it had been adopted by the House of Commons unanimously. So there was an NDP member of Parliament from Vancouver Island who would put this forward as a private member's motion. And what that is in the House of Commons, you have government business, which is the big stuff that the ministers and the government departments bring forward. But you also get private members' business, which is, the individual MPs, whether they're part of the government or part of the opposition, they can bring ideas forward, and they can be voted on by the whole House. And so it was a unanimous vote, 200 and some MPs in favor, and none of them against. And they endorsed Jordan's principle as being something that the government should implement. So fast forward now to 2009, and Health Canada comes up with essentially, I think it was called an MOU, a memorandum of understanding, saying we're going to set aside $11 million to deal with these cases, these Jordan's principle cases. But what ends up happening, and we see this in the evidence in the tribunal case that comes out in 2016 with the tribunal's decision, is that of that $11 million, none of it ended up getting spent. And the reason was because they essentially took every case and said it had to be just like Jordan's in order to qualify for this $11 million pot of funds. And so you had to have somebody who was facing multiple disabilities, and you had to have somebody who was facing a conflict between the federal government and the provincial government, and other requirements. And so in the end, the $11 million of funding lapsed, and they said, well, no, actually, there aren't any Jordan's Principle cases. But the reason there weren't any Jordan's Principle cases, and this came out in cross-examination, was because of this definition, this defining away of the case that was happening, and this failure to really find a way of implementing it that made sense. And over and above that, there was also the fact that it wasn't really put out there or promoted, this idea that you could come forward and have this help from this MOU. And so when we get to the tribunal decision in 2016, the tribunal says, yes, Jordan's Principle is an important legal principle. Yes, it has an effect on what the government of Canada needs to do, and they say that it needs to be implemented. And this is a really important milestone in the evolution of Jordan's Principle, because it was, went from a political statement that was endorsed to what was recognized as really a legal principle of human rights law, which is that you need to ensure that the services are provided without discrimination based on the child being a First Nations child. And this is really important because, well, there's two reasons that it's important. The legal technical reason that it's important is because in Canada we have divided government between the federal government in Ottawa and the provincial government in wherever your home province or territory is, or the territorial government, and they deliver different kinds of services. And so your driver's license is something that comes from your province, but your Canada pension plan benefits comes from the federal government, and those derive from different they call them heads of power. Same thing, criminal law is taken care of by the federal government, but regulation of insurance companies, that's done by the province. And where things get a bit complicated for First Nations kids and for Inuit and Métis kids is that they have a bit of an overlap that they fall within. And an overlap sometimes can be a good thing because you have multiple levels of government that can take their own approaches to certain problems. We have a lot of examples of that in Canadian federalism. But it can also be a problem in that there's a gap and that nobody's doing anything because everybody says it's somebody else's job. And so the federal government has responsibility over, and this is an 1867 term, so bear with me, it's Indians and lands reserved for Indians. And the provincial government has responsibility for healthcare. And that's because of a blend of 2 or 3 or 4 things they're responsible for, that all of them add up to what we conceive of now as healthcare. And so what ends up happening, or can happen there, is that both governments point at each other and say, well, this is healthcare generally. Well, no, this is specific to a First Nations kid. And then there's no agreement. And so just as a matter of how do we sort ourselves out, Jordan's Principle was confirmed as essentially as a legal principle, which is, we have important equality rights in this country, the Canadian Human Rights Act federally, there's human rights acts in the provinces. There's also Section 15 of the Charter of Rights and Freedom. And really the culmination of all of that and other important legal concepts is that you can't pass the buck. And the Quebec Court of Appeal, in its decision 2 years ago in the First Nations the Act respecting First Nations, Inuit, and Métis children, youth, and families, that on whether that was constitutional, they really endorse this aspect of Jordan's Principle, which is to say that it's an important jurisdictional principle that governments not hang back in the weeds and that they play their part. Now, the second aspect that's really important is the idea that you need to meet First Nations kids where they are. And this is the idea of substantive equality. And so we got our first kind of whisper of this in the jurisprudence in a federal court judicial review in 2013, which was about a family in Pictou Landing First Nation in Nova Scotia. And mom had some complex medical needs and had to go into care for them. And her son also had complex medical needs. Mom's were more acute, her sons were longer term. And so the solution that was come up with was, well, the First Nations essentially home care program has run out of funding. And so, Jeremy, Marina Beadle's son, should go into a foster placement. Now, this wouldn't have been good for Jeremy, wouldn't have been good for the family. Jeremy belonged at home where he was quite comfortable and where he could be cared for with some help as his mom recovered. And so the federal court looked at this and said, budget limitations really aren't a good reason to say that we're not going to meet these needs. We have to look, kind of meet the First Nations child where he is, recognized and held on to Jordan's Principle as a commitment the government had made. and pushed the government to ask. That was appealed, and then the appeal was dropped. And this was just a couple of years before the tribunal decision. And so where the tribunal comes down on this, and this is, the fundamentally important principle about this, is that when we talk about services to First Nations kids, whether it's child and family services, whether it's the services that Jordan's principle supports, it's services that are based in substantive equality. And substantive equality is the idea of, you can't just go out into the field and say, well, we're giving the same thing to everybody. We give everybody one pair of glasses. We give everybody, whatever the level of service is, 50 hours of physiotherapy. You need to look at what are the underlying needs, and is there a need that's greater? And using, this isn't a presentation about child welfare, but using that as an example, the Auditor General found in her 2008 report that those were being funded at about 67 cents on the dollar when you compare to the provincial governments. But when you looked at the need was probably even $2.50, $3 on the dollar in terms of the circumstances that communities were facing. And so not only in child welfare were they not funding, to formal equality, which is just giving the same dollars, but they're falling short on substantive equality in terms of trying to get folks to the same outcome. And so the tribunal really, looks at Jordan's principle and says, well, we have a Human Rights Act. This is, of course, the legislation that they're responsible for really implementing in response to complaints and adjudicating human rights complaints on the basis of this. And they say that, that legislation says that when services are provided, it should be in consistent with substantive equality, with non-discrimination. And here as well, we're dealing with First Nations kids. So there's concepts of the best interest of the child that come into this as well. And so government needs to take a harder look at things. And so the first order that's made is actually quite broad. It's essentially stop discriminating and fix it. And the government had kind of the full, panoply of options in front of it to do that. And now this is where we kind of start to tell a bit. The item 1 and 2 on the agenda start to merge a bit here, talking about the history of how we got here and how non-compliance orders work. And essentially what they say is stop it, fix it. We're going to have some questions. We want to know more, and we're going to kind of come in a couple of phases. We're going to have immediate relief. We're going to have long-term reform, and we're going to have compensation. And the compensation really addresses those who have been harmed in the past, and we can't do much more for them than that because the past is past and childhoods are short. Immediate relief for kids in the system now, and then long-term reform is what are we going to get to so we can say it's over and it's not going to happen again. And so a few months after, there's these questions that come out, what are you doing? And what comes out from the government is really, we're going to talk to people. We're going to consult, we're going to discuss with our partners. We think it's going to take about a year. Tribunal comes back and says, no, that's not what we meant. What we meant when we said stop it was stop it. We didn't mean, wait for a year to stop it while you talk to people. And so they order essentially the House of Commons definition of Jordan's principle in April of 2016. And this is in the first, non-compliance order saying, it's time to move forward on this. And here's your definition. It applies if it's between federal, two federal departments, federal, provincial. It's for First Nations kids and to move forward. So more questions get asked by the tribunal and there's submissions by the parties. We have some clarification in September of 2016 that it applies both on and off reserve. So it's not just a non-reserve concept. It's one that goes, through the breadth of the country. And then we get to really the first, real kind of full-throated non-compliance motion in the case, which is in the spring, or I guess late winter of 2017. And it's a response to the government's kind of plan that finally came out about 6 months after the ruling, little less than 6 months after the ruling. And what the government did as a first cut at this process was something, those of you who've been doing this for more than a few years may have heard of the Child First Initiative. And that was something that was rolled out in July of 2016. And the government set aside, just shy of $400 million to do three things. One part of the pot of money, I think it was about $30 million, was set aside for the government's own internal retooling, capacity building, et cetera, to handle requests. About another, 30-ish million was set aside, maybe 35 million was set aside for what was called enhanced service coordination, which I think we know more as, service coordinators or navigators today. And that's the idea of having community organizations, involved with First Nations that are able to do the work of putting together the need with the services, and then about $330 million that was called the Service Access Resolution Fund, which was to be there as a stopgap, essentially, when there was nothing else that could be. There was no other services present that could meet the need. You would go to the Service Access Resolution Fund and have the service approved from there. Now, there were some important limitations that were put on this fund, which is what the real kind of thrust of the non-compliance motion was about. And there were two. The first was that focal points, Jordan's principal focal points. So at the time there were two departments still, FNIB and Health Canada, or the Social Development and Community Partnerships, I think was their branch in INAC at the time. They were supposed to look at a case, and if the case was for the same thing that the province would be doing, then they could approve it. But if it was going to go beyond what the province would do, which is now we're getting into substantive equality, then they would have to look at it, and it would only be in the case of a child with a disability or a short-term condition, affecting the essentials of daily living, was more or less how they called it, that they could approve it. Otherwise it would be denied, and then that's it. And so essentially, two really important limits, which is, echoing back to the approach after 2009, it's starting to look a little bit like, well, the cases have to look a lot more like Jordan's to get approved. Obviously, that's a lot more relaxed than, multiple disabilities and different service providers. But it's still the idea of we're defining First Nations kids' needs by their underlying condition or what they're asking for, as opposed to actually just looking at what's going on the ground. And so there's a motion in front of the tribunal to try and get these limitations lifted. And in May of 2017, the Caring Society was successful, supported by the AFN and the Human Rights Commission and the other parties, to have these criteria essentially broadened to be more, looking at what are the child's needs, and is this service required, to get to substantive equality. So if you're in a situation where, for instance, one case I was involved with in Yukon was about a hot meal program for a school for a group of kids up there, and it's more looking at nutrition in the community versus nutrition in Whitehorse. And these kids need the lift, so it's not a matter of, well, we can point to a disability or a short-term problem. It's no, there's a service that's not available to them that they need in order to have the same learning outcomes, or a chance at the same learning outcomes as their non-Indigenous colleagues living in the urban center. And so this is, it's a big development. But one of the problems was that the government turns around within the next 30 days and takes it to federal court because there are elements of the order that they didn't like. And so there's some discussions that happen over the summer between the government, the Caring Society, and the AFN. And essentially the order is clarified to deal with, what kinds of questions the government is able to ask and when, and to nail down some of the timelines. And this is where the timelines, come out of, which is you have individual cases, which is a case about one child. If there's a irremediable harm that's reasonably foreseeable, they have to intervene immediately. If it's urgent in a way that doesn't involve that irremediable harm, it's got to be acted on within 12 hours, and then within 48 hours for all their cases. For the group cases, which is, a broader, usually a gap in the community, for instance, that the hot meal program I was noting, you'd be looking at the same immediate response where there's, reasonably foreseeable irremediable harm, 48 hours for an urgent case, and a week for a case that's not urgent. And so that's really where we see, Jordan's principle take off, is after that November 2017 compliance order, and the government starts really fully implementing, not fully and completely, but starts a more full-throated effort to get Jordan's principle in place. And so there's some supervision that happens after that, but really, we went from 4,500 requests approved in about I think it would probably be about a 15-month span to, tens of thousands, and then hundreds of thousands, and now we're at millions of requests that are being approved per year under Jordan's principle. So just really the floodgates have kind of have broken open, and that is a reflection of the need in the communities. And we've had, government witnesses under cross-examination in the tribunal proceeding admit that that's the need that's out there. It's not Jordan's principles driving itself. It's that it's finally meeting people where they are. And that's why we're seeing the requests that we're seeing and the volume that we're seeing them. And so it's, things have evolved. Obviously, over time, there have been other issues that have come up. A major one from about 5 years ago was, what to do in situations where kids don't have Indian Act status. It kind of emerged in the first couple of years of Jordan's principle implementation that when the government read the words all First Nations children, the way they were reading it in their, government minds was all kids with Indian Act status. And so that's obviously not the same thing as all First Nations children. And so there was a clarification order that was made in the latter half of 2020 to say, well, when we're looking at this, it's Indian Act status children, Indigenous children resident on reserve, children who are recognized by their First Nation, even if they don't have Indian Act status. It's giving the First Nation that recognition and control over its membership. And then it's children who might not have Indian Act status themselves, but one of their parents do. And it's probably a whole other webinar on how Indian Act status works and Section 6.1 and Section 6.2 and all these things. But because of the complicated way it works, if you have a half sibling, depending who your parent is, your half sibling can have status, you cannot have status, and yet you're living in the exact same house. And so the problem with that one that the Caring Society really brought forward is saying, you got two kids in the same house facing the same circumstances, and one of them can get help and the other one can't. That doesn't sound right. And so that was another situation the tribunal was prepared to recognize. That got judicially reviewed along with the compensation ruling I won't talk too much about, and it was upheld by the federal court, the tribunal's approach to the definition. I'll just briefly mention compensation. So there was a compensation order in 2019 for children who had experienced discrimination because of the failure to implement Jordan's principle. That as well was taken up to the federal court in 2021, and the tribunal's compensation decision was upheld. The government did appeal that decision along with compensation on child welfare to the federal court of appeal, but that appeal got paused while a class action settlement that was related, broader but related, came forward, and that settlement was ultimately, after a bit of back and forth, approved in a way that covered, the categories that the tribunal had covered, and so that process is now being administered through the federal court with the class action process. But the other thing that happens in 2021 is something called back to basics. And so what had happened by the end of 2021 was we had, been building at this point really through 4 years of kind of more complete implementation. And there was this document that had developed in and around 2018, 2019 called the Standard Operating Procedures. And ISC was essentially getting bogged down in procedure and in kind of a more formalistic approach to these cases. And so what Back to Basics really did was, it was, in fact, it's one of the better titles that I've heard of in my life, because it's actually something that, you open the lid and you say, oh, this is really getting back to basics. And it's to look like, what are the information requirements that we really need to adjudicate, these cases? What do we really need to know? And what you need to know is what does the child need? And where's the professional recommendation that's supporting it? Or when we're talking in the range of, cultural supports and services, where's the elder or the knowledge keeper from the community telling us that this is, something that makes sense? And so there's the subjective, what's the experience, and then the objective, yes, this is legit. And you can look at the professional recommendation and take that on spec, because a lot of these professionals, like me, answer to a regulator. And so we're not going to be getting, questionable recommendations and views. There's a bunch of other kind of stuff that goes into back to basics, but that's really the essential of it, is trying to move things in a way that made more sense, and really to presume that when you're dealing with a First Nations kid in Canada in the early 21st century, substantive equality is engaged. And we know this because of the decades and decades of colonial interference in First Nations families, the social determinants of health that affect First Nations kids in very similar ways. I've worked on lots of these cases, and a lot of the times you're changing names and you're changing some elements of circumstances, but you're seeing the same themes coming back again and again. It's bigger than any one family. And so really approaching the case and saying that, we're not trying to prove that we need this for substantive equality. We're assuming that's in the mix, and really looking for, indicators that it might not be, as opposed to going the other way around. And so also trying to make ISC's, job easier as well. And then there's other research that gets approved, projects that get approved by the tribunal to try and set the stage for long-term reform. So that kind of takes us forward to, 22, 23, 24. And I won't step on number 3 because Brittany's going to do a great job of describing kind of, where did we get to. But I will, take a couple of, take the elevator a couple floors up so we can just look at things a little more broadly. And so the story I've told just now is kind of from the genesis of Jordan's family's experience, through to the endorsement more broadly in the community of this being something we need to address, to the law accepting it as something that is important, including Jordan's principle being mentioned by the Supreme Court of Canada in its decision earlier this year, upholding the Act respecting First Nations, Inuit, Métis, children, youth, and families as constitutional exercise of federal authority. It's now a very entrenched principle in our legal order, which is a very important development. And now through to some of the implementation of the orders and some of the kind of pitfalls and ups and downs we've seen along the way in those. But I just want to have a minute to kind of talk about how a non-compliance motion works, because that's kind of been some of the driver of some of this. And so essentially with the tribunal process, you've got the complaint, which is going back and forth between the complainant side and the respondent side. The complainant is the one who says, hey, there's discrimination. And the respondent is the one saying, no, everything is fine. Their story may be more complicated than that sometimes, but we'll just boil it down to that. And under the Human Rights Act, the respondent can be the government, it can be a bank, it can be really a federally, regulated employer or entity. In this case, it was the government, the Attorney General of Canada on behalf of the minister responsible for the program. At the start, it was the Minister of Indian Affairs. Now it's the Minister of Indigenous Services. And then the tribunal makes a decision about the complaint. And so in this case, in 2016, it decided, satisfied there was discrimination, satisfied there's no justification for it. My order is it'll stop. And then they did something important called they retained jurisdiction. That's a legal term. They retained jurisdiction. So they said essentially in less legal terms, I'm going to stick around and make sure you clean up your mess. And so essentially what they did there is they've got the broader order and then an ability for parties to come back to them and some reporting obligations from the government in terms of how is it playing out and what's happening. And the federal court described this as the Justice Favell used the expression, the dialogic approach. And so essentially, dialogic approach, it's the idea of there's a discussion going on here, there's an evolution. And so essentially the way it's worked is the tribunal has given guidance about this is what has to be done. And then the parties, Canada really being the first party with the responsibility to do this, are given the opportunity to work it out. And if there's disagreements in how that's working out, then they come back for further guidance to kind of narrow where we're headed. And so the way a non-compliance motion starts is with something called the notice of motion. So the side that has an issue, brings out its the facts that its concern is based on and what it would like done and result. And then there's a process of bringing evidence forward, because the tribunal can only do something when there's evidence to support the exercise of its jurisdiction. And so the way we've dealt with it is, in the hearing, things happened live. There was a very long 75-day hearing that took, many, many months to get through. And people are butts in seats and witnesses telling their story directly to the tribunal and being cross-examined, right there. In the non-compliance process, we've gone with more paper-based evidence. And so you'll have, affidavits, sometimes lengthy ones, because lawyers like to write, that will have, here are the factual situations and the documents that support the yes, there is a problem, no, there's not a problem. After those affidavits are submitted, there's something called cross-examination. If you've ever seen, most American TV series, it's, there's a lot of finger waving and dramatic moments. At least my cross-examinations are much more boring than that. Some have called them plotting. Don't always get the best reviews from spectators, but it's not about how it looks to people. It's how it reads and what you find out along the way. And so you'll have cross-examinations next. Sometimes you can have requests for further information that arise out of those cross-examinations where somebody says, I don't know that, but let me go check with the shop and we'll bring it back to you. And then once all the evidence is complete, because you've got, the affidavits, you have the cross-examinations, both sides have had a chance to ask the other side's witnesses questions to test the case. Then we get into the written legal arguments, also called factums. And so in this case, the Caring Society is the moving party, went first and detailed its situation. Other parties responded. And then those written arguments take you to the hearing, which is essentially a chance to go before the tribunal, make your case using the art of the spoken word, and where the tribunal has questions or isn't clear on things, they can ask. When the hearing is done, the panel members then take everything away with them. They think about it. They write up a decision. They release the decision, and then you've got the order, and you have to see what the order says. The order may have very clear direction. For instance, Jordan's principle applies on and off reserve. Very clear. Might have less clear direction involving further work between the parties, such as, okay, we're willing to say that, First Nations kids recognized by their First Nation are eligible for Jordan's principle, but we're not going to tell you how that's going to happen. So go away and talk about it for a couple of months and then come back with a proposal. And if there's disagreements within that proposal, we can consider alternatives, those kinds of things, but we're not going to write it for you. And that's, I think, a wise choice the tribunal makes in how it approaches these things, because it doesn't want to impose, very minute decision making on the ground, etc. And so often what you'll see, and there's going to be some of this in the upcoming motion, is there's a very detailed kind of on either side, here's what should happen, and then the panel may pick and choose. They may have some guidance about this and that, and then there's some discussion about the best way to land it, so that it actually does fulfill the tribunal's intent, which is to eliminate the discrimination and hopefully prevent it from coming back. So as I say in the industry, that's my TED talk. It's not the whole thing, because I've got another point to cover in probably another little bit here, but I'll leave it there for now, subject to any clarifying Brittany would like me to do on anything I've kind of passed over along that kind of 25-year overview just now.
That was great. Thanks so much, David. Really, so much information there. It's great. Brittany, do you have anything to add before we move on to your presentation?
No, thank you so much, David. That was an incredible summary of a very long case that really ought to not have been that long. Let's be real. So in terms of non-compliance motion, what's a timeline that we're looking at? So we're looking at a hearing date in September. And what's typically a timeline associated if the tribunal chooses to make an order, David?
Yeah, it can be very variable. So the order on the initial order in 2017 on kind of the definitions and limitations on Jordan's principle took about 2 months to come out, and we had the hearing in the 3rd week of March and got the decision in the 3rd week of May. The non-status question for the Jordan's principle eligibility, my facts could definitely be checked on this one, but I think that took about 15 months to come out. And then the more recent order on capital, that one was almost 2 years to come out. And so it's really quite variable. And then also once there is an order, it depends on what the order is. Is there further work required? The non-status motion is a good example in terms of there was a need to kind of come together and come up with a mechanism and come back. And in that case, there was agreement on the mechanisms. There wasn't a need for kind of further submissions and further evidence and a further decision after that. It was really, here's what we think is a good idea. And then the tribunal looking at whether it had the jurisdiction to order that and then doing so. And then, of course, the other thing to add into the mix is, would there be a judicial review by any party of it? And the judicial review could be expected to add at least 6 months to a year to the process. And then would there be a further appeal from that? So it's not by any means a quick process, but certainly, I think the panel has shown in the past they're very thoughtful and sensitive to these issues, and so the time it takes them is the time it'll take them, and that'll be what they see as appropriate to give the proper consideration to this really important issue.
Perfect, thank you. So I think at this point I'm gonna start with answering some questions posed to me in my presentation, and I have a little bit of a slideshow as well for everybody. Okay. So, as David was mentioning, is this case has been ongoing since the complaint was filed in 2007. The human rights complaint was substantiated in 2016. So that's when the government of Canada was found to be discriminating against First Nations kids. And between 2016 to about 2021, there was significant work to essentially try to get Canada to comply with the existing orders, right? And the existing orders being some of what David described to you with these non-compliance motions and subsequent orders. So since 2016, there's been over 25 non-compliance orders and almost like procedural orders to clarify some things for the parties. And so in 2021, the parties to the human rights complaint, so those being the Caring Society, the Assembly of First Nations, Chiefs of Ontario, Anishinaabe Nation, and of course the Government of Canada, signed what's called an agreement in principle. So the agreement in principle is a non-binding roadmap to stop Canada's discrimination and ensure it does not happen again, both in the First Nations Child and Family Services Program and also in Jordan's Principle, right? So there's kind of two key pieces here. So stop the discrimination and make sure it does not happen again, right? And so this AIP, as I said, was a roadmap to get there to a final settlement agreement that would hopefully achieve this. In this AIP, Canada agreed to fix its non-compliance with Jordan's Principle by implementing a work plan in the AIP that the parties agreed to. And this work plan really stemmed from some of the non-compliance concerns and issues that the Caring Society has been flagging since 2018. So some of you guys might know that the Caring Society, we kept almost what we called our concerns document. So it was really a document that we outlined concerns that we were seeing with Canada's implementation with Jordan's Principle, that families were bringing forward, that communities were bringing forward, that service coordinators were bringing forward. And so we were summarizing those concerns and then proactively suggesting solutions. So what started as an 8-page document in 2018 actually ballooned to a 45-page document in 2021. And that was in part because there were more issues, but also because we were getting a little bit more precise with our suggested solutions, and also because Canada wasn't taking up those solutions. So in the AIP work plan, there was that non-compliance, or that work plan to try to end that non-compliance. Unfortunately, Canada breached the AIP work plan and did not respond to measures to sort of bring it back into compliance. And so what the Caring Society was seeing was that there was an increase of severity of harms against kids, and that was growing as well. And what we were also seeing was that the AIP was giving cover for Canada to continue its non-compliance under the guise of negotiating, right? So the Caring Society left the AIP process to file the non-compliance motion against Canada. And the reason that we left was because there's a provision in the AIP that the parties, saying that the parties could not bring a motion, like any sort of litigation, for example, while also staying in negotiation. So that's why we left. We are still, of course, open to negotiating and being part of that process, but we did make that choice to leave because of that provision and because of the harms that we were seeing against kids. And so, as David said, we filed that non-compliance motion in December. And with the non-compliance motion, we suggest immediate measures that can be ordered by the tribunal to resolve Canada's non-compliance. And of course, we filed affidavits very shortly afterwards in January 2024, just 1 month later, over the Christmas holidays. And in our affidavits, you will see that there are many letters from First Nations and First Nations authorized service organizations, service coordinators, and from families talking about their difficulties and their concerns when they're accessing Jordan's Principle. And so it was a huge honor to be trusted with those stories and with those letters, and particularly for folks to get that information to us during the holiday season, which really told us how serious people were taking this and how serious the concerns they had are. And so this is a very high level overview of some of the concerns that the Caring Study has with Canada's compliance with the tribunal orders. So off the hop, we're seeing Canada not meeting the tribunal order timelines for determining requests. We're seeing things like backlogs and unopened requests in the regions. We're seeing situations where families aren't able to reach anybody at the Jordan's Principal National Call Center and regional contact centers. We're seeing delays in payments and reimbursements for services. And we're seeing situations where Canada is denying requests not based on the tribunal orders, right? So for example, saying that Jordan's Principal is not an income supplement program, but not really addressing, the tribunal compliant rationales for determination, which is of course substantive equality, whether the service ought to be provided to ensure culturally relevant service provision, whether it's needs-based and in their best interest, so on and so forth. And of course, we're seeing situations where there's a lack of timely and compassionate response to urgent requests, where there's those situations where kids are in very serious circumstances and they're not able to access the services that they need because of these delays. So I'm going to get into some of the nitty-gritty of what we've been seeing and why we ultimately chose to file a non-compliance motion, and some of the orders that we're seeking to address these really serious situations. So in terms of urgent requests, the tribunal, as David said, ordered Canada to determine requests within a very certain time frame, right? So for urgent requests, so being those where irremediable harm is reasonably foreseeable, those are to be considered as urgent. And Canada has 12 hours to determine individual requests that are urgent and 48 hours to determine group requests that are urgent. But unfortunately, according to ISC's own data, it's meeting those timelines approximately 30% of the time. In 2021, when the Caring Society and the parties entered into negotiations, we, along with the AIP work plan, developed what's called the back to basics approach. And David mentioned that, talked a little bit about that. And that was really to have an open, transparent process that would be applied in all regions for Jordan's Principle. And one of the things that we identified with ISC is that, families and service coordinators were alerting us to the fact that ISC was like downgrading urgency or almost not trusting that the request was urgent. So for example, in some data from 2018 to 2020, from the National Call Center, just 44 requests that were placed in the call center were considered urgent, which wasn't aligning with what we were seeing, with what families were articulating to us, what communities were saying, things like this, right? So we worked with ISC to develop, sort of provide some clarity for public servants when they're working within Jordan's Principle, so they can identify what an urgent request is. So those include anything relating to palliative care for a child or end-of-life care for a child, physical safety concerns, mention of suicide, or risk of the child entering the child welfare system. So unfortunately, as I said, we're still seeing situations where Canada is not meeting those timelines when determining urgent requests. And in winter of 2024, this delay actually put two children at risk, and also ultimately led to 2 children in Northern Ontario who died because of these delays. And I want to really acknowledge those families and that community who experienced this, because it took a tremendous amount of courage to come forward and really advocate for their kids to make sure that they had the services that they need. And this is ultimately part of the reason why the Caring Society, is choosing to move forward with this non-compliance motion, is to make sure that kids are not being put into that circumstance where they're not able to get their urgent needs met. So some of the requested orders that we have on urgency, and again, what I mean by requested orders is we have suggested these in our non-compliance motion, and we have said why we think that they're would work for kids, why they would alleviate the discrimination throughout our factum and additional submissions. So some of the requested orders we have is to provide some additional clarity on urgent requests. So for example, those kids who have or might experience the death of a caregiver or close family member, and those children who are impacted by a state of emergency, for example, fleeing a wildfire, that those requests would be considered urgent, right? And then we've asked the tribunal to make orders to ensure that Canada has sufficient staff in the region and at headquarters to manage and triage urgent requests, right? And we've also asked that the national call center is updated so that families can really easily identify when their request is urgent, and to ensure that there's actually a staff member at the national call center be there to determine the urgent requests, right? So in the course of negotiations and our work with Canada, it became clear in some of our operating meetings with Canada and with other First Nations that there was indeed a backlog. And so what I mean by that is it's not such an innocuous term. What that really means is that kids are waiting, right? And it's becoming a very big problem. So about a year ago, a service coordinator identified that ISC had relayed to them that there was about 1,000 requests in a backlog in their region. And of course, this was the first time that we were hearing about it, so we looked into it more. And indeed, what we've later found out in the course of cross-examinations was that this is almost, I would say, crisis level, where there are between 40 and 80,000 requests unopened, waiting for determination, right? So this isn't, for example, 40 to 80,000 kids that are waiting for determination. It's requests, right? At any rate, what that means is that there are kids waiting for determinations on potentially urgently needed products, services, or supports, right? And so some of the requested relief that we've asked the tribunal to take an order on is, that Canada will actually just proactively reach out to all those families who are waiting and let them know that, hey, if it's urgent or time sensitive, please let us know. And I let them know who to contact if it's urgent or time sensitive, right? We've also asked that Canada have a triage mechanism installed, right? So that they can triage all the backlogged requests for urgency, and also put in safeguards to make sure that these backlogs do not develop again. So some of the other concerns that the Caring Society has raised is the national call center and other contact mechanisms like the regional call centers. So the national call center operates, or should be operating, 24/7 all year round, right? It is the only place that is available to families to place requests, like on the weekends, after hours, so on and so forth. The regional call centers are only available during business hours. And so what we've been hearing from families and service coordinators is that they're not able to get a hold of anybody at the national call center. There have been, because of the non-compliance motion, we have seen some success and positive steps forward to address the concerns at the call center. and to ensure that there are sufficient staff there to meet the needs of families who are calling in. But we really want to make sure that it doesn't backslide, right? And so what we've asked is that that ISC sort of edit its call tree, I guess you could say, so that families can really immediately and easily indicate whether or not their request is urgent, or in the case of an existing request, has become urgent. So right now, if you call the call center, there is an ability for families to say, yes, my child is at risk. But of course, we kind of view this as a departure from the urgent option at any rate. So some movement steps forward to resolve this as needed. And we really want to make sure that, again, that there's someone at the National Call Center with the authority to review and determine urgent requests. And in some cases, to make sure that the compassionate supports are available if it's not going to be able to be reviewed and determined within the compliant timeframes. So some of the other concerns that we have raised with the tribunal is, very serious reimbursement and payment delays. So in the tribunal orders, Canada has been ordered to make make reasonable efforts to ensure that payments for services, products, and supports are done in a timely manner. So at this time, Canada has adopted a 15 business day sort of service standard for reimbursement, right? But according to its own data, it meets that service standard about half the time, right? And of course, as many of you guys will know, Jordan's principle really mostly operates on a reimbursement model. So the idea being, okay, so the request is approved. The request is for like a wheelchair, let's say. So the family can go out and purchase that product and then place the receipt, submit the receipt to Jordan's principal to get reimbursed. So what we're seeing is significant delays with that process, right? That reimbursement process. And so, of course, that means that families who often aren't even able to pay out of pocket are going into debt waiting for this reimbursement. We're also seeing situations where, let's say it's an approved occupational therapy service or for your child psychiatrist or something like this. So the professional will place their invoice for services for reimbursement for payment to Jordan's principal. And then, of course, what we're seeing is delays with that reimbursement or payment, right? And in some cases, what we have seen is that service providers are simply unable to continue providing services because they're going into arrears, they're not able to pay their staff, so on and so forth. So it's ultimately actually having a real significant impact on the types and levels of services available to First Nations kids through Jordan's principle. And we're also seeing situations where communities themselves are also experiencing increased hardship because of the delays in reimbursements. One community in a northern part of Manitoba, they reached out to the Caring Society because they were owed hundreds of thousands of dollars by Indigenous Services Canada for approved Jordan's principle requests, right? That they had paid for the kids in their communities so that families wouldn't have to be out of pocket for it, right? So that is extremely challenging for many communities who they themselves are on fixed funding, are navigating very serious emergencies in their communities, for example, flooding and wildfires, and may not have the cash flow to float Canada in the interim, essentially. So some of the requested orders that we've asked the tribunal to make is that Canada, for example, report to the tribunal about whether or not it will follow, a different service standard for payment. So, for example, we have suggested a 15 calendar day payment service standard for service providers, so professionals and things like this, and then a 5 calendar day payment standard for families and kids. And we've also asked that Canada report back to the tribunal with really practical solutions to address payment delays. So for example, methods for emergency payments, right? So there are an expansion of the use of acquisition cards. So while Jordan's Principle does operate on a reimbursement model, in some cases, Jordan's Principle focal points can use acquisition cards. And these are really intended to ensure that services and products aren't delayed to kids if the family does not have the capital to wait for reimbursement, for example, right? Or when it's an emergency, so on and so forth. At this point, it's quite narrowed, the use of acquisition cards, and it's not clear to the Caring Society whether it's actually addressing sort of the needs of kids. We're also, want Canada to look into some automation, right? So for example, we've suggested an automated process that presumptively approves all requests under $500 that has a recommendation from a professional or supporting letter from an elder or knowledge keeper. And the reason why we've suggested this is because we've asked the Institute of Fiscal and Social Democracy to look into how much does it cost Canada to determine requests. And so they provided an estimate, and in their estimate, they said, well, it looks like it probably will cost Indigenous Service Canada $536 to determine every request. So we said to Canada, well, if you presumptively approve requests below $500, you're actually saving $36. And we also suggested this because when we looked at some of the data associated with Jordan's Principle, most requests being submitted to Jordan's Principle were for low dollar services and supports and products, right? Low dollar, but high, value for kids and families, right? So most requests were actually below $1,000, right? I would say about 50% of all requests submitted to Jordan's Principle are below $1,000. So by having some automation with the safeguard of, a recommendation from a professional will help ISC to hive off some of those requests. And so some of the other concerns the Caring Society has raised is accountability broadly. So as some of you guys will know, Indigenous Services Canada provides funding to First Nations communities and organizations to hire Jordan's Principle service coordinators. And these coordinators are really to help families access Jordan's Principle. And so in some cases, service coordinators will help families access existing services and supports in the community. And in some cases, they will help families place requests to Jordan's Principle, and so on and so forth. As well, in some cases, ISC does basically fund communities and organizations to approve certain types of requests and to fund ISC-approved services, right? But what we've seen is that these service coordinators are actually becoming the face of Canada's non-compliance, right? So what I mean by that is a service coordinator is placing requests to Jordan's Principle, but then because of the backlog, because of ISC's delay in determining requests, they're ultimately having to follow up with ISC and say, hey, this request is now urgent. The family is telling me it's urgent. Where is the determination for this request? And then in some cases not hearing back as well as the family, right? And so we really want to see in some of our requested orders that Canada will confirm that First Nations and First Nations organizations who have chosen to take on the delivery of Jordan's Principle have the sufficient resources and sustainable resources, including funding to do so, right? Particularly for those communities and organizations who have chosen to take on the funding of approved Jordan's Principle requests. In some cases, we're seeing a very significant delay in those communities being reimbursed, right? Or those organizations being reimbursed. So we want to make sure that there is some processes in place to ensure that that does not ultimately stop service provision for kids, right? And we really want to see that Canada develop a credible, effective, and independent Jordan's Principle complaints mechanism. And so in this case, this complaints mechanism would report on Canada's compliance publicly and step in urgent cases where ISC is not stepping in themselves. And really as a body to make sure that families and service coordinators who have concerns or difficulties accessing Jordan's Principle can go there and have those concerns and difficulties addressed. So at this point, I'll stop sharing because I think we can pop back over to David, or if there's any questions from David and Melissa.
Yeah, you did stop sharing already, so that's great to see you on the screen. There is one question that directly relates to what you've just been talking about, so we'll ask that question now. One person had the question, how is information received or gathered by the Caring Society to file a non-compliance motion? So for example, wait times, applications being stalled, payment delays.
That's a great question. So there's a couple different ways. One is as a party to the human rights complaint, the Caring Society sits on a committee, for example, called the Jordan's Principle Operations Committee. And the intention of this committee is to address operations of Jordan's Principle and ensure that they're aligned with, work with Canada, Indigenous Service Canada bureaucrats to ensure that the operations are aligned with the tribunal orders to address concerns, so on and so forth. As part of the operations committee, it is disclosed publicly what, for example, determination timelines are and the Canada's compliance with that. So we'll receive a report, for example, saying this month we were able to address non-urgent individual requests such and such percentage of the time. And there's another part of that question. Just lost it, sorry.
Right, it was how is the information received or gathered? Around just some examples around the information, wait times, applications being stalled, payment delays.
Yeah, and so in terms of the backlog, the reason how we got that information was, and David actually probably could speak to this better because it was a question that was asked of during cross-examination. So maybe you could answer that question there, David.
Finding my unmute button there. Yeah, so really, I think there was this sense of it kind of coming up from the community of a lot of people saying, hey, we've been waiting a long time. And then it's, coming out through those fora that Brittany was mentioning, like the Jordan's Principle Operations Committee. They believe someone in BC region received information from the ISC regional office there about the state of the backlog in BC. And that was kind of the first thread, sticking out from the tapestry in terms of starting to pull it. And finding out that in fact it wasn't just happening here, it was happening elsewhere as well. So it was not that's one of the issues that we've raised in the motion, is that this was a situation that had been building for some time, but it was not something that ISC was kind of proactively coming forward with. And in fact, we had, I believe it was in the cross-examination of one of the witnesses, we had material from the Minister of Indigenous Services briefing book when she was before House of Commons committee as part of the estimates process. And one of the items that they were briefing the minister about, I think it was far back as might have been the spring of 2023, was we may face too much demand and be unable to keep up with it. And so it was at least something in the spring of 2023 they were worried about. And because under the Access to Information Act, those briefing binders become public and are posted online, we were able to go back and check and see this later. But it wasn't something that we really saw until the fall of 2023, when the community, when community members and regional organizations working in the Jordan's Principle context brought those concerns to the front themselves.
Great, thank you. I know we have a lot of questions to get to. We just have two more parts of the presentation that I'd like to get to first so that we can sort of complete the process here, and then we'll turn to some of the great questions people are asking. So David is now, we've asked him to talk about the position of the other parties in relation to this current non-compliance motion.
Sure thing. So Canada is, unsurprisingly opposed to being ordered to do other things. And given the time that it's been since the motion was filed and since discussions around the problems commenced, I mean, it's if there was things they were going to do, one would think they would have done them. I don't think that's an unfair statement to my colleagues at the Department of Justice or their clients at the Department of Indigenous Services. So their response is that this is really not. These aren't the kinds of orders that should be made, and what they're asking for, and they've brought their own cross motion, which is essentially when you respond to one party's motion by bringing your own motion, is to change the first thing they would like is they would like to have they call it objective criteria around urgency, and that there be an order around the parties getting together to discuss criteria that the focal points would be applying to identify urgent cases, as opposed to the back to basics approach, which is to listen to families and the circumstances that they're in, and to understand urgency from the family's perspective. And this really flowed out of the standard operating procedure era, where from the Caring Society's perspective, a lot of urgent cases got missed because the focal point did not have their attention attuned to what urgency looked like. And the back to basics approach involves kind of prompting the family with examples of what are urgent cases. It's not, it's not necessarily an open season on urgency. It's to prompt the family with, these are the kinds of cases that could be urgent. Is that what you're looking at? So their response to the concern around urgency is to limit or better prescribe what is urgent and what gets into the 12-hour queue. The other thing that they would like to do is change the timeframes. And so rather than having 12 hours for individual urgent cases, they'd like to push that out to 48 hours. And I believe on the group cases, it's from 48 hours to a week. And then on non-urgent cases, they would like that timeline to go from 48 hours for urgent cases and a week for 48 hours for non-urgent individual cases and a week for non-urgent group cases to be within a reasonable time. So essentially an undefined service standard that involves reasonableness. And the government's witness on that, when I asked her about that standard, was to say that she would never use that standard herself. And so it wasn't one that the senior assistant deputy minister at ISK, responsible for the program, wasn't one she supported. So we'll see what the tribunal does with that. And then the other thing that they would like to do is essentially expand the role of First Nations in responding to Jordan's principal requests. And so they say the ability to refer requesters to First Nations so the First Nation can provide the service. There are a few concerns the Caring Society has raised in response to this, one of which is that there needs to be sufficient resources in the community. I saw in the Q&A, some concerns around the Health Consortium in Alberta's ability to reimburse in a timely way, and that can be linked to the funding that they're getting from ISK themselves. So if the reimbursement pot has run dry, they need to wait for that to be replenished, for instance, from ISK. And so, are the regional organizations or are the First Nations organizations that ISK wants to work with going to be resourced to do what they will be asked to do is a really essential question. And we say one that there's not a great answer to based on what we've seen, to this point in the evidence. And the other thing, though, is that they actually don't need an order to do this, because the 2017 orders setting the table for, where really the implementation took off from already contemplate that if there's an existing community service and the link can be made within the 12 or 48-hour timeline, that is perfectly acceptable. And there's also been other times where Jordan's principle essentially serves as a bridge to something else. Maybe there's a waiting period to get involved in some other program, or maybe there's something that requires assessments to get on the list for, but it can be a bridge. And so this idea that there's a need for further orders or guidance from the tribunal to be able to triage or to assist in connecting with existing services, that's not something that's required on the tribunal's existing orders. And that's something certainly we've pointed out. AFN, for its part, is opposed to the relief the Caring Society is seeking. They didn't bring their own motion, but they're nonetheless making some requests for, or telling the tribunal what they think that the orders should be, and they have some orders that they would like to see around some changes to the timelines to make the non-urgent timeline a bit easier, and I believe the urgent timeline would stay about the same. And then on timeframes for reimbursement, the Caring Society, like Brittany was mentioning, has proposed 5 and 15 calendar days for individual or business essentially claims. And they would be looking at 10 business day standard for individuals and 15 business day standard for reimbursing service providers. So, in the ballpark of the Caring Societies, just a bit longer. But the main concern too that they're looking at from the AFN's perspective, at least on my reading of their submissions, is that this isn't going to be something that impedes the long-term discussions on what will be the future state of Jordan's principle, the long-term reform that allows the tribunal to, essentially, I said earlier, they're sticking around in the room to make sure the work gets done. Well, eventually they will leave, and what are the conditions on which they can do that? And so they're looking at time limited relief, that they've looked at going out to the end of March of next year, or a settlement agreement, essentially whichever comes first. The Commission and the First Nations Leadership Council, which FNLC got intervenor status in July, and they're a regional First Nations organization in British Columbia, are generally supportive of the Caring Society's motion. And then Chiefs of Ontario and Anishinaabe Nation, which are also interested parties in the human rights complaint, have largely taken no position, although they have kind of aligned themselves with AFN's submissions on this thing to this point. So that's kind of where everybody else stands in the lay of the land.
Great, thank you. Thank you. The one last thing we want to speak to before we get to the Q&A is Brittany's going to speak to the implications for long-term reform, both in relation to Child and Family Services Final Settlement Agreement and the forthcoming Jordan's Principle Agreement. Thanks, Brittany.
Thank you. So I'm just going to share my screen again. Wonderful. So as David and we've talked about is, really what we're trying to do with this human rights complaint broadly is to stop Canada's discrimination in First Nations CFS and in Jordan's Principle, both now, and ensure that there's effective safeguards in the future to prevent it from happening again, right? And so we've really envisioned 3 paths to doing this, right? So there's negotiation, which is for example, the agreement in principle, which can lead to a final settlement agreement, would be considered negotiation. This requires, of course, agreement by Canada, approval by First Nations leadership, and ultimately has to be approved by the tribunal, right? And then, of course, there's litigation, right? So it does not require agreement from Canada necessarily. And party positions should be consistent with First Nations directions. And of course, for example, it's public, right? So everything that we've talked about here in terms of the non-compliance motion, right, that being considered litigation, is publicly available on our website at fnwitness.ca. So in terms of how we see this happening and resolving this discrimination is we actually, most likely it'll be a combination, right? So where we can agree with Canada and the parties, where all the parties agree, we'll get a consent order on that. Where there's not agreement, most likely that will have to be resolved in a tribunal process. And the benefit to the combination approach is that we can ensure that the tribunal orders, for example, stand, right? So tribunal orders do not expire, right? They could be forever until a final settlement agreement, for example, replaces them. So in terms of the long-term reform, many of you guys will have seen that in July, there was a final settlement agreement announced by the Assembly of First Nations, Canada, Anishinaabe Nation, and Chiefs of Ontario for First Nations Child and Family Services Program, right? So those parties came up with negotiated agreement, a final settlement agreement for FNCFS. It is draft at this point. Latest information is it's still being, there's still regional engagement on it with First Nations leadership. And there will be, my understanding, an AFN Special Chief Assembly at some point, potentially in late October, beginning of November. So what we do know at this point is that, of course, that final settlement agreement does not include Jordan's Principle. So the final settlement agreement on Jordan's Principle is not out in the world yet. But what we can see from the submissions by the Assembly of First Nations in Canada is essentially some implications for how the negotiations on the Jordan's Principle final settlement agreement might go. So in AFN's May submissions and Canada's also May submissions, they suggest negotiations only amongst the First Nations parties. So between the Assembly of First Nations, Chiefs of Ontario, Anishinaabe Nation, alongside with Canada, right? And this is concerning for a couple different reasons. One, it doesn't include all the human rights, all the parties to the human rights complaints. For example, the Caring Society, the Human Rights Commission, and Amnesty International. It also does not necessarily include all the voices of First Nations, right? And so what, for example, the Caring Society has recommended for long-term reform, for negotiations towards the final settlement agreement on Jordan's Principle, is that the negotiations are presumptively open, right? It includes all parties, and that it's also informed by technical experts in all regions, and that these negotiations are accountable to First Nations, right? And so ultimately the Caring Society is open to agreement with Canada, but we would like to retain the right to litigate where Canada will not agree or where Canada breaches any final settlement agreement, right? So ultimately what matters the most to the Caring Society and what we want to see in terms of long-term reform is high quality, substantively equal, culturally and needs-based child and family services and Jordan's Principle services, right? Our kids deserve absolutely nothing but the best. And so that's what we're looking for. We want to ensure that Canada is complying with existing orders on the books, right? The tribunal orders are the minimum standard, right? They are not the maximum threshold, right? They are the orders that Canada are binding, that Canada has to follow to address its discrimination, right? So we want to make sure that Canada is complying with those existing orders. We want to see, for example, evidence-informed funding structures, policies, and agreements that end discrimination for kids and families, not just in a 10-year cycle, right? We want to have some surety that our kids are not going to have this fight again in 25 years, right? So we want to make sure that that discrimination is backstopped, is ended and backstopped by some evidence-informed solutions beyond year 10. And we want to make sure that there's effective safeguards against Canada discriminating again, right? So that can take place, for example, in a tribunal process, another accountability body. But at the end of the day, once the tribunal ends its jurisdiction, we need to turn our minds to how do we ensure that Canada does not discriminate again, right? And so that takes me to my last point, which is access to justice for First Nations and First Nations families, to ensure that they are able to access the human rights orders and that standard that's been ordered now, but also in the future, right? And so that's sort of what we're thinking in terms of the long-term reform of Jordan's principle. And of course, as I said, it's not still outstanding, but definitely keep an eye out for that. And in the meantime, keep an eye out for the human rights hearings in September.
Thank you. Thank you so much, Brittany. David, do you have anything to add or questions for Brittany, or Brittany questions for David? And we're going to move into the Q&A section. We do have the webinar space for another half hour if our presenters are available to stay. There are some questions, many questions that have been answered in the Q&A. Thank you so much, Jennifer and Jess. But we do have some that we need our presenters to address if possible. But let me just give you a chance to say anything else you want to add to what Brittany said, David, or a question from Brittany.
No, I think in light of the time, I'm happy to do the uncommon thing for a lawyer and stop talking.
Okay.
So I unfortunately I've got another call at 2:45, so I'm good until about 2:40 because I'll just need to cleanse my brain. It's in a different area of the world. It's about airplanes. So I will I've got 10 minutes for questions, no problem.
Okay, that's great. Well, I'll try to get to the ones that maybe you can help answer as well. Okay, the percentage of overturned appeals are so high, more than 62% of appeals are overturned. Is the government taking anything from the high instance of appeals and applying it to the initial review of applications?
Yeah, I'm certainly not aware of anything, from the lawyer's perspective. Certainly, I think that that's a really good indication that there might be a need for some recalibration when it's up to 62%. But Brittany, I'm not sure if you're aware of anything at the Jordan's Principal Operations Committee where folks are looking at trying to drill down, into, are we seeing commonalities with this 62% where we could try and retool?
Yeah, that's a wonderful question, and it was actually something that was asked at the Jordan's Principal Operation Committee meeting a few months ago, or a couple of months ago, and it was ISC is getting back to us on that one. So certainly what that tells me is that they are aware that there needs to be some recalibration, and that they're looking into this as well. Yeah.
Okay, thank you. Another question that probably one or both of you could address is, will there be any changes to non-urgent timelines? I know that we don't know what the results are going to be in the orders that come out. It just says that some are waiting for something as simple as school supplies with the 4-month time. Will the 4-month timeline be changed, or 4 to 6 month timeline be changed? Kind of already spoke to this, Brittany, but
yeah, well, I mean, the tribunal orders is that for non-urgent individual requests, those have to be determined within 48 hours, right? We know that that's not happening not even majority of the time, probably approximately 30% of the time, and it's being heightened because that issue is being heightened because of kids waiting in what is calling a backlog. So the tribunal order is the 48 hours. That's the order right now. Of course, we don't have a magic ball where we can see what the orders will be in the future, but as of right now, that is the order.
yes, and it's just not being complied with.
That's right.
That's the additional non-compliance order. How many non-compliance orders have there been for Jordan's Principal overall?
That's a great question. I don't have the number off of the top of my head, but I know overall there's over 25. David might. David looks like he might.
Yeah,
but overall 25.
It's how you count a non-compliance order is a bit of a term of art and depends on who's doing the counting. But I think you can really identify kind of 5 separate buckets. I'd say you'd have the early ones in 2016, which were really more about kind of which direction Canada was going to point itself in. The big one in 2017, which was about, once Canada did set out on an implementation journey, the limitations that it imposed on that. So I'd say that would be 2. The third one would be the whole issue surrounding Indian Act status and who is or isn't eligible. The fourth, I would say, would be the issue of capital. That was common to the Child and Family Services program, but essentially it was, well, we're going to have all this extra operational money, but we're not going to have the space in which to provide the services. And then the fifth bucket, I would say, would be this round now, which is kind of about maybe for lack of a better term, a lack of adaptability on Canada's part to kind of meet the moment and how it's changed in the last 3 years.
Right. Buckets of non-compliance. Okay, that's wild. David, just like, I'll ask you this one before you have to go. We have a question: would a new government coming in at the next election affect how they run Jordan's Principle, or does the order mean they have to keep it as is? This person has heard worries about this.
Yeah, I mean, certainly a change in government will change many things as it does in a democracy. There are parameters, though, that can't change in terms of the substantive quality component and the time that the government has to respond, unless there's, as the government has tried to do now, an amendment to the order that's based on evidence and what's in the best interest of kids. And so there is durability to these orders in that they are, legal orders that apply to governments of any stripe. However, that being said, there's no question that politics has played a role in bringing us to where we are today. You just have to look at the implementation that happened under Stephen Harper's government, which was an $11 million fund that went nowhere. The orders have certainly helped, but they've been paired with, at different times and at different levels, political will on the government's part. And so what that looks like for an incoming new government is going to be incredibly important. That's also where the community's voices are going to be incredibly important, because the political will we've seen from this government, when we've seen it, hasn't always been a natural, thing that's just come out of nowhere. It's been, 2016 was on the heels of the TRC report. In 2015, that was the wind in the sails that really pushed the government to take steps forward and not to go to federal court and judicially review the tribunal's ruling. In 2021, it was questions about compensation asked during the election. It was the tragedy that was revealed, it was made really into public consciousness at Tecumlip's, which, those who've been following this a long time through the TRC reports knew that these things are happening. And even more importantly, those living in the communities have known about this for generations. But the public consciousness of it, is what, in my view, as a, armchair political commentator who lives in Ottawa, and I say armchair in that it's, in the four walls of my house and sometimes with friends like here, that's what pushed the government, where it went on the compensation ruling, where before it seemed to be very much bent on, its judicial reviews and its appeals, and it came to the table in a meaningful way after the election. And so it's going to be very important if there is a change in government, and frankly, even on this government as well, to keep making this a priority, for there to be pressure from the community to do this right, because as Cindy Blackstock likes to say, kids are worth it.
Absolutely, thank you. Maybe we have you for a couple more minutes. So I'm going to ask this question to you and Brittany. What can people do if they're not hearing back, timelines not being met? So there are many variations of this question being asked. When an application is at the national level and marked as urgent, what are options for families to move the process along? Or application has been sitting at a national level for over 6 months.
So I'm going to say this with a caution that, when you're a hammer, often many things look like a nail. And so, I'm a lawyer, and so I have a certain view of solutions to problems. But I think, my general view is that squeaky wheels get grease. And so I think, continuing to raise the issue and document and paper the file that the issue has been raised. We have, in part of our remedies, we'd like to see as a complaint mechanism, just for this reason, so that there's somewhere to go. If you read our materials, you'll see, the Caring Society has tried to play that role from time to time, but there's only so much that it can cover, because it's only, a handful of people. What we need is a properly resourced ombuds function, like we have in so many other federal areas. The veterans have a veterans ombudsman who can advocate for veterans who aren't getting services, in a proper way. And we need, it's in that kind of parallel line for First Nations, kids looking for services under Jordan's Principle. But at the end of the day, if depending what you're looking at, again, it's like this, the stakes of the stakes of the situation kind of match the stakes of or the stakes of the measures kind of match the stakes of the claim. If you're dealing with, a claim for school supplies, it's hard to kind of bring the sound and the fury for that when it's kind of caught in the same morass that everybody else. But where lives are at stake, where it's large numbers of kids that are at stake, where it's big money on programs, like there are avenues and there are levers that you can push, in seeking out legal counsel. There's a device called Mandamus. I had an organization I'd helped with that, where something had been blocked for a year, and a couple of angry letters and a draft pleading later, very pleasant angry letters and a draft pleading later, it unblocked, because the squeaky wheel gets the grease. If there's any Lord of the Ring fans, here, the Eye of Sauron, shifts, its attention. And then it's just the good work that the Caring Society is doing and trying to push these forward, the good work that everybody on the Jordan's Principal Operations Committee is doing to try and bring bigger attention to this. And so also just ensuring people know, if the BC rep hadn't spoken up about the information they got from ISC about the backlog, it might have been more months, until we learned about this and were able to kind of take more cohesive action. So again, sharing knowledge and sharing information is a huge part of this, for sure.
Yeah, and just to add to that, I mean, that's such a good point, is, one of the concerns the Caring Society has raised is that ISC is not necessarily raising these concerns themselves publicly, right? Or at least as well as the parties, right? So it was very concerning to the Caring Society, for example, as a party, that we did not hear about this backlog from ISC themselves, right? And so all that to say, as a family, if you're having concerns, you're waiting for a request, determination back on your request, you're waiting for reimbursement. I did talk about the concerns the Caring Society has with the National Call Center and the regional contact centers, but that is one of those levers that you can use, right? Call the National Call Center. We have seen some improvements with it. And say, I'm waiting X number of days, weeks, months for my request. Let them know if it's become, urgent, meaning if the services aren't provided, your child might come to irremediable harm, or if it's becoming time sensitive, right? Meaning, for example, it's not necessarily harm, but it's, for example, I'm going to miss out on this assessment for this child because the service provider can't wait any longer, for example, right? I had a question earlier just saying, I've been waiting months. Can they not, and the time has passed since, my child can access the service. What happens now? Well, let ISC know that, and see what can be done. At the end of the day, ISC still owes you and your child an approval or denial on that service, requested support. And so just because they're delayed doesn't mean that you won't eventually get that, and you ought to get that, because that's in the tribunal orders as well.
Great, thank you, Brittany. I'm just going to take this opportunity to say thank you so much, David. Brittany, are you willing to stay on for a few more minutes and answer?
Of course, yes. Thank you, David.
Yes, thank you so much, and we'll talk another time. Take care. Thank you.
Thanks very much for the opportunity to talk about this important stuff, and thank you to everybody on the call who's doing the work in the community. It's really incredibly important work, and it makes a huge difference in the lives of families. And I know there are a lot of frustrations that happen. Particularly, it's important to address those, but also bear in mind all the good that's happening too, the approvals that you're able to get through. So congratulations, and thanks for everything.
Thanks for all your work, David. Thank you. Okay, Brittany, I have a few questions for you. One is about kind of the role of service coordinators. They receive a lot of blame shifted onto them, and the community has not provided enough transparency on when or if approval funds transferred to our agreement, or even invoice requests, whether they are paid or not. Is there any way to get financial transparency in order to support the approvals? Otherwise, this comes out of our program dollars.
Yeah, so just to clarify, so generally speaking, service coordinators, there's a couple, you can almost think of it as a couple different tiers, right? So there's service coordinators who are in the community to assist and support families in placing a Jordan's Principle request, right? So this could be like helping out with the paperwork, making sure that, you've got the letter of support, things like this, right? And so often what we're hearing from families and from service coordinators is, oh, my service coordinator hasn't gotten back to me on this, right? But it's usually because the service coordinator themselves hasn't heard back from ISC, right? And so they're waiting to hear back, right? So it's important to ask, the service coordinator, like, what exactly, their role is, vis-a-vis Jordan's Principle and ISC. If you have, if you're working with an organization or a community that has the ability to fund certain Jordan's Principle requests, you can ask them that, right? Or they will disclose that. Not everybody has that capacity or has chosen to take on that role, to be clear, right? Some communities and organizations have very clearly, they don't want to take on that role. And that's part of self-determination, of course, right? So key with the funding is the request still has to be approved by Jordan's Principle by Indigenous Service Canada, right? So if you've placed the request and you're still waiting to hear back, it hasn't been funded yet, it's likely because it's still being, like, the service coordinator is still waiting for the determination. So certainly don't hesitate to reach out to service coordinator and to ask where the request is at. Most service coordinators that I know are managing so much, and don't hesitate to ask. And alert them if it's becoming urgent or more time sensitive, right? Because they will relay that to Indigenous Services Canada. And of course, you can always call a 24-hour call center yourself, right? And say, hey, this request was placed on behalf of my service coordinator, and I want to know where it's at. Like when can I expect to hear back on a determination as well, right?
Oh, that's great information. Thank you. Just to let everyone know too, you should be able to see the answered questions in there, and there's lots of great information in there as well. Jen and Jess are doing a great job of doing that. Let's see, there's a question here. How can I, as a support person, try and keep Jordan's Principle accountable? I've spoken with the MLA in the riding. They're also at a loss for what else I can do. It's just supporting families in some remote communities in BC who have urgent requests that have been going on for about 8 months.
Oh my goodness, yeah. Well, it was really great that you reached out to your MLA. I would also suggest reaching out to your member of parliament. So this is the individual that sits in the parliament, so the federal government apparatus and parliament here in Ottawa, right? Reach out to them and say, hey, this is a legal order. Canada has been ordered to determine this request in such and such 12 hours for urgent requests, 48 hours for non-urgent. And this family has been waiting 5 months, 6 months. What you have suggestions about what we can do? In some cases, members of parliament can make inquiries, right? I'd suggest reaching out to your member of parliament. I would suggest calling a 24-hour call center and your regional contact centers. I know it sounds, redundant, but I can't, as David said, it's really important to let ISC know and paper for them when the request has become urgent, when they haven't gotten back to you, so on and so forth, right? And if the request is really urgent, I would also suggest reaching out to the Minister Patty Hadju. So this is the cabinet minister who's in charge of Indigenous Services Canada. And you can write her a note, an email, and say the exact what I just said regarding the MP. This is the delay, these are the orders. Can you look into this, please? Right? As well.
Right, so like keeping a paper trail and evidence for your specific situation as well.
Yeah, exactly.
Right, so one person, was when you were talking about reimbursements, we were gonna ask you this question, but I wanted to get things, finish the presentations.
Mm.
Can you speak, about some vendors not accepting the payment procedure by ISK?
Yeah, that's a really great question. In some cases, vendors or professionals are not able to wait to be reimbursed by Indigenous Services Canada, or they have done this in the past, and because they have waited for so long, they're choosing not to do that. So if the vendor that you're working with, the professional you're working with, has indicated that they can't work with ISK, I would relay that to ISK or ask the vendor to do that. In some cases, ISK can set up a direct sort of payment process with the vendor directly, right? Depending on who it is. In some cases, ISK can, purchase the items themselves and then, with their acquisition cards, internal acquisition cards, and have the product or service sort of delivered to your child. So there's a number of different scenarios. All that to say, don't hesitate to reach out to ISK and say that. In most regions, if you go to, and ask my colleagues Jen and Jess to put the contact details of the Indigenous Services Canada website in the chat. If you look at sort of the regional contact information, there's like one for requests and there's one for payments and reimbursements. Don't hesitate to reach out to the payments and reimbursements folks. Over at Jordan's Principle, if you're having concerns or difficulties, or the vendor you're working with isn't able to sort of connect with ISK, right?
This is related to, does a non-compliance motion cover this, that some vendors are not accepting the payment procedure by ISK?
So what we have alerted the tribunal to is that because of what we have seen is that because of ISK's delays in reimbursing some service providers, some service providers have indicated to the Caring Society and to service coordinators and to families that they're not able to be reimbursed by ISK, and in some cases they're choosing not to deliver services to kids who are receiving supports through funded through Jordan's Principle, right? So we have alerted ISK or the tribunal to this concern, and we've provided some evidence of this in our affidavits, and now it's up to the tribunal to make orders on this to try to alleviate this concern and this evidence of children not being able to access services. They will not be able to make an order to compel a provider to deliver services to through Jordan's Principle, but they can try to potentially make the process a little bit more accessible for families and service providers if they want, right? In those orders.
Okay. There was a question earlier, and I think Jen's just maybe put some of these questions together, that people were asking some questions about capital and Jordan's Principle, and if you could speak generally to that, please.
Yeah, that's a great question. So in 2021, the tribunal ordered Canada to fund capital projects. So, and there's kind of like two similar but somewhat separate streams for capital. So there's one for the First Nations CFS agencies, and there's one through Jordan's Principle. So I'll just talk about the Jordan's Principle one. So for Jordan's Principle capital, what that means is buildings, infrastructure, etc., that's needed to deliver Jordan's Principle services, right? That's sort of how it's worded in the order. So the other caveat for Jordan's Principle services, it has to be on reserve, right? So it's not necessarily you're not necessarily eligible to submit a request for Jordan's Principle capital off reserve, right? Definitely, I think my colleague placed some infographics here in the chat for you. Definitely check that out. At this point, I do not believe that Indigenous Service Canada considers housing like a capital request, given that that's for an individual child. That if it's a housing request or like a request related to modifying a house for a child's accessibility needs or remediating mold, for example, or renovating an existing house to meet the child's needs, that needs to go through the Jordan's principal request process, not the capital process. The capital process is more for delivery of services, so buildings and things like this. So I've seen First Nations, for example, place requests for a multiplex building that would house services related to occupational therapy, speech language therapy, things like this. So those types of requests would go through the capital process.
Oh, wonderful. Thank you for clarifying that. Just one last question for you, and we'll end the webinar for today. Will the hearings be available to watch live, and where should we watch for the links for that?
That's a great question. So APTN and it will be there, should be there to film it. And they, I believe they're going to be live streaming it as well. The National Film Board will also be filming the hearings. We are still waiting to hear back from the tribunal in terms of whether or not it's going to be in person or a hybrid or fully online hearing. And the reason why we're waiting to hear back is because the tribunal needs to confirm space for the hearing. So all that to say, do keep an eye out on the Caring Society social media platforms, so Facebook, Twitter, Instagram, and on our website. As soon as we have information about how you can watch and take part in the hearings, we will post it.
Fantastic. Thank you so much for this, Brittany. And for everyone who attended, thank you so much for joining us and asking great questions. This has been videotaped, and we'll be able to get it up on our YouTube channel. It's a long weekend, so Tuesday or Wednesday next week. Just check there, and the URL has been posted, I think, a couple of times in the chat section. The other thing I'd like to say is we will send a follow-up email with our list of links that have been posted in the chat, as well as the URL to the video for the webinar, and you're free to share it widely. Thank you, everybody, for joining us today. And thanks to Jen and Jess in the background, who've been doing a fantastic job. Couldn't have done it without you. So thank you so much, and have a great day, everyone.